How do doctors get their day in court to be vindicated without having to put their house or their nest egg at risk? Fortunately, there's something called a HighLow Agreement. It's been around for some time, but it's very infrequently used. It's a technique that you must know about. The alternative is that you'll just write a check for $1 million, the case goes away, but that doesn't feel good to a doctor who believes he did everything right in taking care of a patient. It's a contract, an agreement that each side enters into before court. So the doctor still presents his case to the jury, and the jury renders its verdict, but ultimately what the doctor pays and what gets paid to the plaintiff is determined by this agreement. Let me give an example. So the before picture could be anywhere from $0 to $10 million, but with the agreement, it may have bookends of $100,000 to $1 million. So in this particular case, if the jury comes back and says the doctor is liable and owes $10 million, because of the agreement, the doctor only owes $1 million. Policy limits, he does not lose his house. On the other hand, if the jury comes back and says the doctor wins and otherwise owes nothing to the plaintiff, here because of the agreement, the insurance company needs to write a $100,000 check. So the patient or the plaintiff walks away with something. The good news is that even though the patient receives some money, in this case $100,000, it's not reportable to the data bank. A HighLow agreement is something that you should talk about with your attorney in advance of going to trial. For more information or to join our mailing list, sign up at info@medicaljustice.com.